evening session will cover several topics, which will include comments on the SRC International Trial, which have got some controversy in Tanzania, especially with the judgment of Dato' Rahman Sabli. It's a dissenting judgment, which attracts a lot of attention from the legal fraternity. Then there is also the 1MDB trial, where sometime last week, Najib that faced 4 offences under the MACC Act and 21 offences under Section 4 of AMLA Act. The court finds a prima facie case made out against Najib and called upon to make his defence. And sometime early December, the defence will start. I will invite Tan Sri Shafi later to make some comments on it. Then there is that so controversial elusive addendum. Addendum, for which I will invite Tan Sri Azharul to comment on the addendum, because with his background as a former speaker of Dewan Rakyat, I'm very sure Tan Sri is very familiar with the way the government machinery work or don't work. And then Tuan Adli, I would like Tuan Adli to comment later on the remarks made by former Court of Appeal Judge Sultan Hamid Baker. He made a very controversial affidavit making allegations against the judiciary, and was covered by the former Attorney General Tommy Thomas in this book, My Story, Justice in the Wilderness. Quite a lot of chapter on Justice Sultan Hamid. And I think it is best that I begin by inviting Tan Sri Shafi, and as we go along, Tan Sri, I'll pose additional questions, and members of the panels are free to chip in on any topics. So you're not confined to just your respective topics. Okay, in that case, Tan Sri, I would like you to come here and explain to the audience here what's your view on the trial that just took place. And we know that you made some comments on hearsay evidence, and we know you were not happy with some of the witnesses. So if you can have your views on this, as well as what's your plan of defense in respect of Dato' Najib. Don't have to tell us everything, but just a gist of it. Thank you. Ada mikrofon? Okay.
Thank you and good evening. I presume the question is limited to 1MDB at the moment. Yes. Now, in 1MDB, there are too many facts for me to load onto you today. But you can ask me a very precise question. I'll be able to respond to satisfy you. But let me take the matters of 1MDB in a general sense, and yet very critical. The main allegation in 1MDB trial, we're talking about the allegation of abuse of power, namely the Section 23 offences of the MACC Act. Now, in all the 4 charges that have been preferred against Dato' Sri Najib, you will find rather shockingly, every single witness, except the formal witness from MACC, these are investigators and so on, except those people, every witness that are civilian witnesses, if I may put it that way, again with one more exception, Tan Sri Baki Sai, who is now the chairman of Petronas. So, get this clear, all witnesses in 1MDB, with the exception of Tan Sri Baki Sai, all have admitted being bribed by Jolo. all have admitted that. Every single one of them, especially the CEO of 1MDB, one person by the name of Datuk Syarul, he has admitted that he took instructions from Jolo. Now, he took instruction from Jolo on everything, yeah? There was no personal input or counter check or taking the matter to the board for a discussion and to make a more considered judgment on matters that involve billions of ringgit. He never did that. He merely took the instruction from Jolo under one excuse. When he was confronted, he said, I thought this is Datuk Sri Najib's instruction. So when we further asked him, did you double check with Datuk Sri Najib? Because this can be what the Malays normally call jual nama. You know, it is so often that it happens. If, for instance, the Kamodin is the MB of Selangor, one day he will be, I think. Now, I could easily say to the clerk somewhere in the land office, and I said, well, the MB has given me the go-ahead. The clerk work is to double check through her bosses whether the MB actually has given that consent. Now, this person by the name of Datuk Syarul is not a fool. He is a graduate of Stanford, Berkeley, and then he went into technical training before he took up a position as a CEO in Accenture, which means he is fully aware of matters of governance, matters of cooperation, and so on and so on. Interestingly, he met Jolo much earlier than Datuk Sri Najib, because he was with Jolo. Jolo was his so-called client when he was in Accenture, and Jolo was in UBG. You remember UBG? It's quite a controversial company that was initially owned by Tun Muhammad Taib, the former chief minister of, and then who became governor of Sarawak. There was a controversy as to how Jolo took over UBG. All right? Now, so Syarul was very close to Jolo for a very long time. Now, he took instruction only from Jolo. The whole management was behind Jolo rather than behind the board of directors. This is proven. Those of you, I notice some of you very familiar in this hall. You have followed the trial. This is a fact that is admitted. All right? To such an extent, when Syarul was giving evidence, he was rather in a cheeky manner described that Jolo as the man who carried out the orders of Datuk Sri Najib. And he says, if you remember the movie Godfather and the book Godfather, he says the person who held the position as a legal advisor to the family is exactly what Jolo is to Datuk Sri Najib. He was a right-hand man. But what he has admitted thus far, so I asked him, you know, he used an Italian name, which was cited in that book to describe the position of Jolo to Datuk Sri Najib. Yeah, consider it. Now, I then asked him, because since you use the Italian name, can I ask you whether you are in fact, because he said he just followed Jolo. Even drafting of the letter, drafting of talking points to the board, everything was conducted by Jolo. He took it and executed the instructions. So I said, in Italian, you must be supra mobile. Supra mobile means you are just a table ornament. That means you are not the real CEO. So he was stunned. He never responded because what he said made him straight away where it hurts most. Okay, that is the CEO. The subsequent CEO carried the same way. They too say, well, we followed the instruction of Jolo. We followed the instruction of the top management. That is because we have always thought Jolo's instruction must be the voice of Datuk Sri Najib. Now, I can tell you now, you can check the records, it is accurate. I have confronted every single one of these witnesses, including Tan Sri Baki Saleh. I have asked, did you have an occasion to talk to Datuk Sri Najib and confront him and say, look, this matter is very serious. Apparently, it is your instruction through Jolo. Can you confirm this? Not a single witness said they did that. That means they never approached Datuk Sri Najib to confirm if this was his instruction. Correct? Now, why do you think the prosecution adopted this attitude of saying there is a top-down approach, namely Datuk Sri Najib gave instruction to the one MDB people, and then this matter then is carried out as his instruction. The reason for this is this. One is, of course, and I tell you, Tan Sri Azhar is a lot more qualified in company law than me. He will tell you, in company law, the biggest organ that makes big decision where it involves substantive amount of money or funding will have to start from the board of directors. Of course, the management feed the board of directors with information, with various numbers, research, and so on. But once they decide, whichever way they decide, they push it up to the shareholder. If the matter requires shareholders' approval, because some matters require shareholders' approval. So it is never top-down, it is a rather down-up approach. Now, Datuk Sri Najib's defense has always been, when papers come to me for a shareholder to sign, or representative of the shareholder company to sign, I have always been told that the board of directors have agreed. They have discussed and they have consented to it. And that is the reason why I signed. And he said, as a Prime Minister, Minister of Finance, where would I find the time to investigate each one of these papers, whether they are correct or not? And he said, I cannot do that. Moreover, he said, if I were going to abuse the one MDB company, I would choose people who are not so clever. If you examine the board of directors of one MDB, all of them, let's take, commencing with Tan Sri Baki. Tan Sri Baki did financing and corporate management at LSE, London School of Economics in London. One of the best schools you can find in this area. Then you have subsequently another chairman that took over, equally qualified. He was an accountant, well trained overseas. Then you have Tan Sri Izmi. Tan Sri Izmi was a chartered accountant, became what you call it, Tabung Haji, be a CEO, and various other postings that he has taken. Extreme. Then you have businessman Ashwin Balira, who is well qualified, exposed to matters of business and so on. And you have also people like Tan Sri Go from Penang, who apparently was a person involved with the property business that was brought in because of his qualification. So Datuk Sri Najib said, what is the use of bringing the most qualified person if I cannot rely upon my board of directors?
3 more minutes, Nancy.
Yeah. All right. Now that's very important. for you to bear in mind. There is no such thing as top-down, but rather down-up approach. Now, the second point I want to raise is this. Datuk Sri Najib has always said, in this case, you will be shocked if I were to summarize for you this way. His management failed him because the management around in the 1MDB are all associated to Jolo. This is confirmed even by Jasmine Lu, who recently testified. Jasmine Lu was the Consul General, meaning she was in charge of all legal matters in 1MDB. Yet she testified she took instruction from Jolo. Right? And she is a protected witness. She's being protected from what? I don't know. But apparently she's a protected witness by the police. So the management failed her. The board of directors failed Datuk Sri Najib because they did not do the check and balance of all the project that goes through the management and subsequently to the board. That's number two. Number three, he said, 1MDB bankers, and his personal banker is M Islamic. M Islamic failed in their duty. In fact, the evidence of that is that Bank Negara slammed them with 2.9 billion ringgit penalty for their misconduct in relation to 1MDB. Then he said this financial advisor, namely this big bank from New York, apa nama ni? Where Tim Lesnar was, yeah? Okay. Goldman Sachs was the advisor, financial advisor. Goldman Sachs and Tim Lesnar and Mr. Ng, you remember, who was convicted in New York together with Tim Lesnar? Ng is now here. They failed him as well because if you take the cases in New York, Tim Lesnar has been convicted, not sentenced yet for the last 2 years. I don't know what kind of system US have got. Convicted, but for 2 years not sentenced yet. But Mr. Ng has been sentenced, but in spite of being sentenced, again, I do not know what kind of law New York has got, because he's allowed to travel here by escort, of course, to face another trial in KL. But that trial has not commenced for the last few months. Okay. And lastly, if I may tell you, of course, bankers like BSI, Falcon Bank in Hong Kong and Singapore, all failed him. All of them has been punished by Singapore. BSI Bank today is closed down, shut in Singapore and various other places. They are only operating in Switzerland. Falcon Bank totally shut down because of misconduct by the bankers, are all in relation to 1MDB. Lastly, he said, my last bastion is Bank Negara. I told Bank Negara I'm getting this donation money. I declared, I gave them the 4 letters from the Arabs. But he said, central bank, especially the governor, failed me. Because the governor and her families, maybe I should say the governor's families, the husband and the 2 children, got something in the region of 280 million Singapore from Jolo. So you tell me why my client, Datuk Sri Najib, is the only one facing the charge. I think I stopped there.
Okay, thank you, Tan Sri. Thank you, Tan Sri. Basically, what I will do, the first round of question, I'll give the panel 10 minutes each. Thereafter, I got many more questions, which just require very short answer of less than 5 minutes. Yeah. Okay, the next question is to Tan Sri Azhar Harun. Yeah? Being a former speaker, he's very well versed with the way the government machinery works. Especially the politics behind the government machinery. I think we're all concerned about this elusive addendum, yeah, regarding detention of Najib, house detention of Najib. some say is there, especially if you look at the affidavit of Datuk Sri Zaid Hamidi, Wan Rosdi Menteri Besar Pahang. They say it is there, and they saw it at the handphone of Tunku Zafrul. These are very senior leaders. I don't think they joke around with topics like addendum. They don't joke around. And then suddenly you find the Minister of Home Affairs say is hearsay. I believe my knowledge is of Article 42 under the Federal Constitution. It is the Pardon Board is just an advisory body, Tan Sri. It's just an advisory body where the clemency has always been the royal prerogative. Clemency has always been the royal prerogative. I think I would leave it to Tan Sri to elaborate to the audience here whatever he knows about this topic of addendum. Please, Tan Sri.
Thank you very much. Assalamualaikum semua. Thank you very much for having me here. I have to begin with a disclaimer. I'm not here to support anybody. I'm just here to talk about the law. Okay. Now, let's start off with the power of the Agong. That's in Article 42. The Agong has the power to pardon, to grant respite, and to grant reprieve. So many people forget about the last two. Kita cuma cakap, we only speak of pardon. It's not. There are powers to grant three things: pardon, reprieve, or respite. Yeah, and this may take several forms: full pardon or conditional pardon. Commute. You commute a sentence, or you give remission. Yeah, so everything is quite different. Basically, the point is his power is not only to pardon, but also to grant reprieve and respite. So if you talk about reprieve and respite, it's a very wide term. Alright, he may suspend a sentence, he may lessen a sentence. So if we talk about him giving a discount of 50% of the imprisonment, that's part of it. Giving a discount on the fine, that is also part of it. And of course, if he says instead of you being in the prison, you should be in the house, yeah, I would say arguably it can be done because the power is wide. We have to remember this power of pardon come from the time when the palace, the king, was the one and all who was powerful in the country. Yeah, at that time the king was the one who made law, the king was the one who judged people, the king was the one who give petition to listen to petition from the people, and of course the king was the one who can grant mercy, forgiveness. Because it is mercy and forgiveness, that power is personal to the king. That is part of the king's prerogative. Alright? Then they came one day and the king woke up and say, hey, I'm so busy lah. So I will give the function of making law to parliament, the function of listening to dispute to the court. Right? So lepas tu adalah court. But then he still retain the power to grant pardon because that is part of the king's prerogative. And this is also preserved in Article 42 of our Federal Constitution. Alright? The jurisprudence on the king's power to grant pardon, reprieve and respite, I think is quite settled in Malaysia. It's quite settled because there are two cases, I think C. Kim Chun and then there was another one. Federal Court already state it is the king's personal power. He is not even bound by the Pardons Board. He's not. The Pardons Board can make a recommendation. He can take that into consideration, but he's not bound by it. The court has settled that. In fact, in the latest case, which involved PMX, somebody challenged his pardon. I think Hanif Khatri my learned friend Hanif Khatri did the case. I can't remember the name of the applicant, but it went up to Court of Appeal. Court of Appeal say it's non-justiciable. It's the king's personal power, and he applied for leave to appeal to the federal court. Federal court refused leave. So the law is settled. The law is settled. The jurisprudence has been built. There's a body of jurisprudence in Malaysia, and as of now, it is settled. It is the king's personal power. I think the Bar Council pun tried to challenge recently and it was dismissed. Yeah. So it's quite settled. Yeah. Now, what happened in Datuk Sri Najib's case is, of course, Tan Sri Shafi filed judicial review. Was it for mandamus? A mandamus is an application to compel the government to do something. That's mandamus. Yeah. Judicial review involve three main matters: mandamus, certiorari, and prohibition. Prohibition is where you go to court and asking the court to stop the government from doing something. Mandamus is the reverse. You are asking the court for an order to compel the government to do something. Certiorari is your application for the court to set aside a decision by the government. Alright? So this is an application for mandamus. Okay. I have to explain the procedure a bit. When you file for judicial review, there are two stages. One is the threshold stage, stage 1. Once you establish a prima facie case, the court will grant leave, and then you go to the next stage, which is the merit stage lah. You hear the merit. Now, the threshold stage, stage 1, is actually ex parte. Only one party. Only Tan Sri Shafi. But he has to serve on the Attorney General. The practice is the Attorney General will come running to the court and he will ask to be heard also. Although it is ex parte, he will come and say, no, I want to be heard. Normally the court allows that. Then when the court allows that, it will become an opposed ex parte. It's not inter parte, it's not both party. It's an opposed ex parte, meaning the Attorney General can come and ask for leave to appear as opposed inter parte, ex parte. He cannot file affidavit. He cannot. He can only argue point of law. His role is very restricted. Alright? So what we have in this case is, Tan Sri Shafi filed a case. There are two affidavits, I remember. I haven't seen them, but all these are all in public domain. I wasn't involved in the case at all, okay? Now, there are two affidavits filed, first by Datuk Sri Zahid, Timbalan Perdana Menteri, and the other one is Datuk Sri Wan Rosdi, Yang Amat Berhormat Menteri Besar Pahang. Both, they say this. Both of them say this. Tengku Zafrul, MITI Minister, has told us that there is an addendum asking for house arrest. Stop there. Okay. Stop there. Now, in ordinary situation, that will be a hearsay. Because I'm coming to court, I say, so and so tell me this. That's hearsay. Alright? But, here, the affidavit did not stop there. The affidavit also say Tengku Zafrul showed us the addendum from his smartphone. So what the result of that is, these two deponent of an affidavit, Datuk Sri Zahid and Yang Amat Berhormat Datuk Wan Rosdi, actually saw the addendum. They saw the addendum. That's not hearsay. That's not hearsay anymore. You see, when I go to court and say, Encik Azli told me Tan Sri Shafi's car is black, that's hearsay. But when he showed me a picture, here, this is Tan Sri Shafi's car is black, then I saw it. Then it's no more hearsay. That's not hearsay. Then it is admissible. What happened after admissibility is probative value. What's the probative value of that evidence? What is the weight to be attached to that evidence? That's totally different. That one you deal with at the second stage, the merit stage. Here is just threshold. The court say at threshold state, I just have to show some kind of arguable case, prima facie, that this case is not frivolous. That's all. So with all due respect to the learned judge of the High Court, I totally disagree with it, with his judgment. It is not hearsay in the first place. And in the second place, you deal with weight at second stage. Let the government go to the second stage and file their affidavit and see what they say, whether they have it or they don't have it. That is how it works. But unfortunately, the learned judge, of course, he disagreed with, or rather, I disagree with him, with all due respect to him. Alright? Now, be that as it may, in court procedure, stage 1 of judicial review is what we call interlocutory matter. Interlocutory matter. You see, in one action, when I sue Tan Sri Shafi for defamation, there are a lot of interlocutory matter. I might file for disclosure, discovery. Yeah, Tan Sri Shafi might think that I cannot pay costs if I lose. Then he file for security for costs. All these are what we call interlocutory matter. Yeah, the matter between the filing of the summons until the full trial, they are called interlocutory matter. Now, in the rule of the High Court, hearsay is admissible in interlocutory matters on the condition that I disclose the source of my belief. So here, both Datuk Sri Zahid and Datuk Sri Wan Rosdi have disclosed the source of their belief, and the source is the Kuzafrul. So that is where we are now. This is where we are now. With all due respect, I disagree with the learned judge's finding that it was hearsay, and I hope Tan Sri Shafi, you appeal. Have you appealed? Yes. So Tan Sri Shafi has appealed. So I know it's sub judice, but I'm just articulating the law as it is. As it is. Okay. Some lawyers may disagree with me, but I'm convinced I'm right. That's why I'm standing beside you. I'm in front of you, and I'm sitting here in front of you to tell you what the law is. Alright? So, this now brings us to the response from the government in the public arena, in the public domain. Because the government did not respond in court. Tengku Zafrul, he filed an application to file his own affidavit, which was, with all due respect to him and his lawyer, a totally wrong procedure. Because he's not a party. He should have done that. But anyway, it's not for me to criticize his lawyer. I mean, he's got a top-notch lawyer to act for him. Now, but this matter, in my opinion, with all the respect to the government, to the learned judge, ought to have been given leave so that we can articulate the whole issues, the merit, the weight, the probative value, and we want to hear what the AG has to say on evidence. Because at stage 1, opposed ex parte, the AG cannot put in affidavit. He just come to raise some point of law. He may say, oh, notice is short notice ke, short serve ke, itu saja. Only technical. So merit is here. Alright, then we move to the public arena, the political arena lah, because the matter has become political lah kan, it involves politicians. So, now I remember the response by Menteri Dalam Negeri was, saya belum melihat addendum tersebut. Saya belum melihat. And then we come to PMF new statement. I still remember what he says, saya tidak masuk campur tangan. Okay, in the parliament, Minister of, Menteri Dalam Negeri went a step further and said it is all hearsay. With all due respect to him, it is not hearsay. You see, you cannot simply cling to a legal term without fully understanding it. Please don't. But okay lah, I mean, you all are politician. I mean, I'm a lawyer. I understand what it is. Tan Sri Shafi understand what it is. Atli pun. But it's not good when we cling to a term just because we want to avoid answering. It's a parliament. The answer is, Datuk Sri Taki asked whether there is or there is no addendum. Alright, so whether he can jawab or he cannot jawab, I will come to that. Then Menteri Undang-Undang stand up and say almost the same like PM Act, saya tak campur tangan dengan perkara peguam negara. But peguam negara is under her. Menteri Undang-Undang, dia peguam negara under dia, mahkamah under dia, SPRM under dia ke? I'm not too sure. Whether I think SPRM pun under her. I'm not too sure. I could be wrong. But these two, court, parliament dengan peguam negara surely under her. We are not saying that she should campur tangan. But when a question is asked about these three agencies, then she should be answering it. The procedure is simple in Dewan Rakyat. MP submit the question to the speaker. We sit down, the speaker and the secretariat, we sit down and go through the question and whatever, and then we give nombor kepada question tu. Top 10, top 15, top 40. Top 10 is important because top 10 ni lah yang akan dijawab secara oral dalam Dewan. Top 12 sometimes kalau ada masa. Ya, yang lain tu jawapan bertulis. Alright, so when we put in the list, then the minister concerned should prepare, should get the answer and read the answer out in the Dewan. That's how it is. Okay, now
3 minit lagi, Tan Sri.
okay, I'm coming to that. I'm coming to the final point. The final point is this. I think this polemic about the addendum shouldn't be there. Datuk Sri Najib, he has been convicted and sentenced 12 years and berapa 100 million fine, whatever. He has then filed a petition diraja untuk pengampunan. He has filed a petition untuk pengampunan. He is a petitioner. Dulu-dulu orang kampung akan pergi ke istana and say, ampun tuanku, patik tak ada makanan, lembu patik mati sakit, ayam pun mati, telur pun tak ada, beras tempatan pun tak ada. Ampun tuanku, minta tolong. That's how petition work. So here is Datuk Sri Najib. He has been convicted, fine. He's been judged and convicted, fine. He has petitioned for mercy, for pardon. Now, he has a legitimate expectation to know the full result of his petition. That's why I'm here. I tak sokong siapa-siapa ya. That's why I'm here. My 37 years of practice and what they call activism is about this. I go to court, I fought for Raja Petra for nothing. Apa yang dapat pun, parking pun I bayar sendiri. I do all those election petition for nothing. Petrol, parking semua I bayar sendiri. And I'm here today because of this. Orang tuduh saya, I've been bought. Maria Mokhtar tuduh saya macam-macam. But this is me lah. I penyebut. He has a legitimate expectation to know the full result of his petition. You tell him the result, so that he know the result. Then kalau dia tak agree, he will come to Tan Sri Shafilah. He will say, Tan Sri Shafilah, I don't agree with me. Can you tell me what I can do? Then Tan Sri Shafilah will advise him lah. You go to court ke, minta revision ke, apa, whatever lah. But he has the right to know the full result of his petition. Pure and simple. Itu saja yang dia nak. Itu saja yang I nak pun. Kalau ada, ada. Tak ada, tak ada. What is so? Okay lah. I mean that it might be political lah. I tak tahu. But the fact remains that. Can you imagine? You sue me. You sue me. And then you tak tahu result. Hakim tak nak cakap. How? You tell me. What is going to happen to our rule of law when people are not told of the result of their action? Legal action. And this is why we're here. I'm not accusing the government of anything. In the normal course of business, kalau ada pardon, addendum ke apakah, that document will go to Jabatan Penjara. Because Jabatan Penjara lah yang nak execute benda tu. So katalah pardon tu kata full pardon, macam PMX dulu dia dapat full pardon. So dokumen tu akan dihantar kepada penjara. Because prisoners ni dia di bawah kontrol penjara. Ya, dia nak datang parlimen pun dia kena minta penjara punya kebenaran, bukan speaker. Penjara punya kebenaran. So kalau dia benarkan, barulah dia boleh keluar, because he is in his control. So first of all, that pardon paper, pardon result will go to the penjara. Then I suppose a copy to minister lah kot, because penjara keamanan the minister. And in normal course also, it will go to Bahyu, Bahagian Hal Ehwal Undang-Undang, which is headed by, of course, Minister Azalina. And then that document bila sampai kat Bahyu, it will be given to Jabatan Program Negara for advice. Valid ke, tak valid ke, how do we execute it, macam mana nak execute. All these things are bureaucracy lah. Dia punya step A, B, C, D, E. So kalau macam tu step dia, then somebody must know, right? Jabatan Penjara must know, Kementerian must know, Bahyu must know, and Program Negara must know.
Yeah, exactly.
Or either one. At least Jabatan Penjara will know. At least. Yeah. So question is asked in the parliament. I don't know why all this saya tak masuk campur tangan, saya belum lihat. Ya, you belum lihat, tapi ada ke tak ada? Itu je. And I think that it is only fair that the petitioner be made known of the full result of his petition, because itu petition dia kepada raja dia.
Yeah.
And only raja, only agung exercises this power of mercy. That's all that I want.
Yeah, thank you, Dazi. Thank you.
Thank you.
Gentlemen, I think that's very enlightening by Tan Sri Azhar on the status of the addendum. Okay, the next question, Tuan Adli, a very important one. This concern the book by Tommy Thomas, My Story, Justice in the Wilderness. Any member of the panel can join in because it's very controversial. I refer to the chapter whereby Tommy Thomas referred to the Anwar Ibrahim trial 1.0, the first trial of Anwar Ibrahim. Tommy said that in the High Court Criminal Division, it was K.C. Vora, the resident judge. But for the Anwar Ibrahim trial, they transferred K.C. Vora out and replaced by J. Augustine Paul. Looks like familiar story, Tan Sri Shafi. Looks like, sounds very familiar. So when they put J. Augustine Paul to be the judge in charge of Anwar's trial, Tommy Thomas said that sealed the fate of Anwar. Gone case Anwar. And Tommy said this, he said it's a kangaroo court by Augustine Paul, and I followed the trial. Augustine Paul was very heavily on the prosecution. He doesn't give the defense a chance. I remember the defense got no chance. So he was very one-sided, and all because Augustine Paul was a close friend of the late Mokhtar, Attorney General. So Tuan Adli, as a litigator who goes to court, do you feel comfortable or do you feel at unease when you go to court that you're going to get a fair trial?
Okay. Bismillahirrahmanirrahim. Thank you, Tuan Haji Kamarul. Assalamualaikum warahmatullahi wabarakatuh, and a very good afternoon. Ladies and gentlemen, thank you for coming today. The question from Tuan Haji is actually it's a normal litigation lawyer question sebenarnya ni. Okay, and today we're going to talk about the Untold Story lah. So I want to talk more on what will happen if, let's say, you will end up with a judge that you know is pro-prosecution or not pro-prosecution. Well, the first cardinal rules as a lawyer is to know the judge. If you know the judge, then you know how to control the judge or whatever you want to convince the judge. This is why we call it litigator. Because you go to court, we litigate, we are telling the judge that this is our view, our point of law, and our submission in order for us to win a case. That's my first answer to Haji. Well, on the case that had happened, I think it's the case. I just came back from UK actually. The case happened, so I'm here as on the floor. I'm very junior actually, so I'm very proud of having together the panels, and thank you for the organizer to bring me in and give me my point of view. Well, I'm telling a story that I think nobody will knows about it, because Anwar Ibrahim did call us in 1997. I was in UK. We went to London. My wife was there together, and he talked about the case. He spoken about the case. He said, "I will be, this is happening. It might be his tenure and all of the tenure as a TPM. I might be charged." Those are the things that they called to us. Students from around the UK came out, and we listened to that with him. And when I came back, it happened. He was charged. I'm not saying that I'm pro UMNO, so I'm a member of UMNO since I was youth. It's difficult for me to enter and become a member of UMNO. If I told them that I am a law graduate, I did law in London, I'm a lawyer, you won't get it, you won't become a member. Those days. Yeah, boys at the back there, I think he knows what I'm talking about. Well, the first cardinal rule I spoken just now is that when you enter the court, you must know who's the judge, and of course you must acknowledge and respect your opponents. I think nowadays, Tan Sri, if you go to court, it won't happen that much, isn't it? If you go to court, the senior lawyers won't have any seats. Those days, when I've been trained, you saw a senior lawyer like Tan Sri and Tan Sri Art, you must give the quorum will come in front. But nowadays, I think it's lesser and lesser. The respect is not there anymore. So back to our point of view, I think today the audience or the reporters here today, the medias, wanted to know about post-school case. So what happened? I think it is because I've been requested by UMNO online to give my point of view or point of law on the case, the current case, the 1NDB case. So I write through and maybe about 2 pages of summaries about the case and what are the preparation that we have to do as a litigation lawyer when your case has been called for defense. So I make some few points. It's been published in UMNO online, and today, alhamdulillah, I've been called and I have the opportunity to tell you what are the things that we have to prepare. With due respect, Tan Sri, you are much more senior than I am, but I've been there too also, and I think what the public know as a member of UMNO, not only UMNO, orang UMNO, member lain apa ni, Tan Sri, member dia boleh tukar parti, tapi dia member UMNO lagi, dia boleh tukar sokong sana sokong ni, tapi I orang UMNO, I tak ada jawatan pun. I come here because orang-orang di bawah sana, the grassroots, especially the members, wanted to know what's going on right now, because there's so many of who are there, Najib going to be released, this and that is very bad. This is the forum that we need to spell out what's going on and what will be done and what will be the tactical things that our defense team, the Najib's defense team, which is led by our Honorable Yang Arif Tan Sri Shafi, to win this case, because we have a decided case in SRC. I read through quite thick decision of Court of Appeal, not the federal court. The federal court I don't want to read because it's nipis je, tak nak dengar je hujah hantu saja. Tu my point of view. But on the Court of Appeal tu ada benda-benda yang I think it shouldn't happen in this 1NDB trial. Maybe I like to tanya nanti Tan Sri tentang first foremost, kalau kita tengok the 44 pages of the keputusan oleh yang Arif Datuk Colin dalam kes 1MDB, whereby the first thing he mentioned about the charges. Normally as a litigation lawyer, kita akan challenge on the charges first. Charge ni tak lengkap dan 80% kita akan kalah lah. Tapi pernah juga menang Tan Sri ya. Pernah juga menang charge tu, bila sampai di Court of Appeal dia reverse. Dia kata charge is defective, maknanya kes tu buang. Ada. Tapi dalam kes bosku ni, kes 1MDB ni, charges tu kata can be cured. So kita nak go elaborate on that. First thing, dalam stage call for defense, if I were the defense lawyer, I won't go on that route anymore, because the judge have decided that the charge is defective. I might be wrong. Tan Sri will be elaborating it later maybe. And secondly, it's about the hearsay rules. Dengar cakap. Tadi Tan Sri Ad pun ada cakap tentang the hearsay rules. Tapi yang ini agak mengherankan. Apa yang cakap saya akan mengherankan ialah orang yang mengarahkan untuk keluar duit masuk duit tu, paling senang keluar duit masuk duit ni, yang bosku pun ataupun Datuk Najib pun tak tahu duit tu masuk tu, ya, tak ada, in absentia. Whether or not boleh ke tak terima pakai witness yang ada prosecution witness yang kata ini semua Jolo punya arahan, dan Jolo kata ini kata-kata daripada bosku. Boleh ke terima undang-undang hearsay tu? Dalam keputusan untuk call for defense tu, hakim kata boleh terima. Itu satu. Yang kedua ialah berkenaan tentang penerimaan dokumen-dokumen yang disediakan oleh IO, Investigation Officer, yang mana diterima walaupun ianya adalah cebisan-cebisan dokumen protestan dari dalam sumber dalam luar negara dan juga di dalam negeri. How come you want to accept that? You know, you cannot accept a document. But in MNCC punya Act, Section 41 ni, Tan Sri, 41A, boleh terima. Dan hakim percaya benda tu ada dokumen tu ada boleh diterima, can be used as a evidence. Now, I've been chatting dengan Tan Sri Ad tadi. Tan Sri Ad point another point of law. Dia kata, now if let's say it can be admissible, whether or not the document itself proven to be that there is a case to call for defense, the prima facie case. Those are the laws yang kita kena challenge nanti, for me lah, if I look into that position. Yes. Sebab later on the judge listen to the prosecution witness, of course. Tan Sri Datuk Sri yang eminent tadi, yang Tan Sri cakap tadi tu, tapi mereka mengatakan cerita pasal, oh no, saya terima arahan daripada Jolo dan Jolo ni merupakan mirror of the accused or Datuk Sri Najib, which I totally disagree. Dan the judge did say in his judgment, in this ruling, dia katakan bahawasanya that it is a normal way of doing business in 1MDB like that. So those are the challenge yang the defense have to bring a doubt. Kita kena raise doubt untuk kita menang kes ni. So bila kita raise doubt, baru kita boleh menang. Dan kita kena convince the judge bahawasanya there is doubt. It's not as simple as what usually the lawyer say, oh senang kita raise doubt. No, kita kena go online on the position of the decision by the judge. What will be the point that we can raise that the facts of the case is doubtful? Satu. Yang kedua berkenaan tentang sebab kita ada 4 charges, 4 charges di bawah MACC punya Act dan 21 charges bawah AMLA. So the next simple thing that I like to confine in a nutshell is that yang 21 charges of AMLA tu, duit-duit yang dibagi tu, adakah ia merupakan duit untuk cuci wang? duit haram, ataupun accused didn't know. Dalam SRC case, kita cuba, saya baca on the decision tu, the 3 judges doesn't believe that Najib doesn't know the money claimed from Arabs. Ada surat-surat dia yang daripada Saudi. Itu ada surat-suratnya. Only thing macam mana nak susun surat-surat daripada Saudi. So that's why kita kena bring, kalau boleh lah, kita bring witness from the Arabs tu come and give statement. Itu yang ramai di luar sana buat pendapat, dan saya pun kalau boleh kita seminar lah, ataupun kita minta supaya dia orang hadir kalau boleh. Sebab itu akan menguatkan kes defense ni. Kalau tak dibuat, then the second LRC punya matter akan come in. Benda yang sama, the judge doesn't believe that actually what happened is benda ni telah dirancang awal-awal, scheme of things. Kataan scheme of things tu ada dalam judgement SRC. So those are the danger yang kita orang di bawah sana, we feel that we have to challenge this statement. Dan I believe that Tan Sri Syafiee ada jawapan-jawapannya, dan saya harap hari ini jawapan ni akan dikatakan pada press, supaya di bawah sana taklah teragak-agak bahawasanya benda ni macam ni sebenarnya datang ada dia punya fakta-faktanya. For example, yang The Age punya owner datang jumpa dengan bosku, ada kan dalam judgement tu tulis kan, dan bosku kata dia kata bosku give the way out. Actually bosku yang pernah saya jumpa lah, dia memang kalau you datang dia akan jemput, dan bila keluar dia akan hantar you dekat apa ni, dia keluar macam tu. Dia punya cara dia, bukannya dia kata get out, dia tak ada cakap pun. I think dalam statement dia punya witness statement tu tak ada macam tu dah sendiri ya. No, tapi tak keluar dekat press. So hari ni kita trash out benda tu, keluar kat press, beritahu, dan barulah kita tahu kes ni baru betul. Don't tell me the judge doesn't read newspaper. Okay,
terima kasih Tuan Adli. This question I posed to Tan Sri Syafiee. Tan Sri, this is regarding IPIC, which has been hanging around for what, 6-7 years now, and no trial yet. Okay, some time ago you said IPIC plan to pay around US 8 billion. Assuming that is paid, I believe no reason to go against Najib and Iriwan Siriga, isn't it? Since the government has got back the money, which is 6.6 billion paid by Najib to IPIC. That's the basis of the charge, breach of trust charge. When I'm referring to one prince from UAE, he came over to Malaysia, met Tun Mahathir, the Prime Minister then, met Attorney General, and they were supposed to settle the arbitration proceedings in London. Because I believe if that is settled, then there is less pressure on YMDB. That 6.6 billion is covered by the payment from IPIC and from the settlement of the arbitration proceedings, nothing hanging. So, is there anything that you can share with us on this issue, Tan Sri?
Thank you. The question of the arbitration and the settlement with regards to IPIC has become more complicated because of one reason. The matter has been put on track during Datuk Sri Najib's time for arbitration to take place in London. That was already triggered. But first and foremost, in order for IPIC to provide the compensation or if I can call it the obligation to pay 1 MDB, certain payment from 1 MDB has got to be undertaken. And that was what that took place from 1 MDB to IPIC. But when the government changed, this entire arbitration and the agreement was cancelled by the new government. So as a result of which, we are completely at a loss because IPIC no longer is bound by that agreement. If that agreement still subsists today, we have hope of recovering that money which you have just mentioned. That is the short answer to all those complications. We have cheated ourselves.
Thank you, Nazri. Thank you, Azhar. Yeah? I think the public well know you as a human rights activist, yeah? And then your blogs cover topics on human rights. Now, what we see here, Najib is facing all sorts of charges, criminal charges, civil charges, yeah? And I think he's the one in history going to court almost every year and every month, yeah? And from the look of it, if IPIC proceeds 3 more years with IPIC and another 2 more years with OMDB. So, Tan Sri, my question is, as a matter of human rights, is it fair that a citizen like Najib face this kind of a situation that his life for the last 5 years and for the next 3 or 4 years will be spent going to court?
Yeah, I mean, he has so many charges over his head. Yang dah habis cuma SRC. Now one MDB prima facie case has been found and defense has been called. Of course, I follow the case a bit, but of course the case has got thousands of documents, tens of witnesses, so I don't really know the ins and outs of the case lah. So when Tan Sri Shafie mentioned IPIC just now, I sort of remember there was an arbitration in London, but I also remember there was some question of law, jurisdiction, whatever. So I can't really remember point of law that was involved. But one thing that always struck my mind about Datuk Sri Najib's case is this. Is it possible for him to really have a fair trial in Malaysia? It always disturbed me. Let me just elaborate on this. When Justice Nazlan found him guilty, everybody hailed Justice Nazlan as a hero. He was a legal hero. Yeah? He was hailed as the best judge around. No, with all due respect, I have the highest respect for Justice Nazlan. I mean, intellectually and academically, he's probably the best, first class honors, right? Honesty, integrity, I'm quite sure he has in abundance. But at the back of my mind, at the back of my mind, now, he was hailed as a hero, as this light in this judicial darkness that we have, like Tommy Thomas wrote in his book Justice in the Wilderness, a book which I have not read because I'm not good at reading fiction. So now, can we just step back and reverse the situation? What if Justice Nazlan had found Datuk Sri Najib not guilty? Can he go to the mosque of Friday prayer or not? Answer me. Let's be frank. Can he go to the market or not? Can he walk into the supermarket or not? What will happen to his family's Instagram, Twitter, his wife Facebook? Come on, let's be frank. Tell me. Boleh tak? Just be frank. Be honest.
I believe no.
No, right? Boleh? Now, bearing your answer in mind, would any judge be brave enough to declare that Datuk Sri Najib was innocent? Now, that's a threshold question for whether is a fair trial really possible for Datuk Sri Najib in Malaysia. That is always at the back of my mind. I'm not, with all due respect, I'm saying I don't want to commit contempt. I have the highest of regard for the court. I was once appointed as a judicial commissioner myself. My brother was a judge. You know, I never have any problem with the court, right? But I always think, okay, take the recent case that VV Yusof apa tu fashion ballet. Katalah dia pergi court. She has been condemned by 32,999,999 citizen of Malaysia. Boleh ke dia ada fair trial? Katalah dia pergi court. Take the GISBH, the ahli Kuan. They have been condemned to hell by everybody. Can they have fair trial ke? So this question, I'm here in the middle. I don't support anybody. I have always been me, and that's a problem with me lah. Okay, but that's for me to deal with. But I always think, was a fair trial really possible for Datuk Seri Najib? I'm just trying to confront this, you know. And I always ask, what will happen to Justice Nazlan? He say Datuk Seri Najib was not guilty. You tengok decision yang dulu yang kata Bung Mokhtar tak ada prima facie case. You tengok komen. You tengok Malaysia Kini punya komen. You look at what they say against Tengku Maimun in Malaysia Kini, where my brother filed for contempt in the federal court. Dia tak suka saja, dia kata macam-macam, prostitute lah, whore lah, apalah. Oh my God, it's so we have, I think there will come a point of time when we need to confront this, okay, because it's a reality. It's a reality, and I think I'm asking a valid question. I'm not saying that Datuk Seri Najib did not have a fair trial, but just as Tommy Thomas say it was a kangaroo court, we can also ask the same question about Datuk Seri Najib, right? I can't really remember the Sodomy 1 case. This is a long time ago. Yeah. A long time ago, but of course, Justice Augustine Paul, the late Justice Augustine Paul, was a really tough judge. Okay, I faced him during my Raja Petra case, and he almost put me in for contempt also. I remember that. But you know, let me tell you about my first encounter with Justice Augustine Paul. I need to tell you this. It's a good story. I have a case in Malacca, and the learned judge was Justice Augustine Paul. So I drove all the way to Malacca those days. Those days tak ada smartphone semua, but there were handphone already. So I drove all the way. So I went there, and my opponent was there, a lady, and in the course of submission, I mentioned a statement of law, which I thought was tried law. So I did not bring any book or any case or any precedent. I did not bring. So he looked at me stumped, and he said, Azhar, are you sure that's the law? I said, I'm very sure, Ya Allah. That's the law. That's what I learned in my masters. I said, that's the law. I can tell you that's the law. He said, you have any authority? I said, I thought it was tried law. I'm so sorry, Ya Arif. I did not bring any authority. I thought it was so established. So, and then he looked puzzled, and he said, okay lah. He said, do you, he asked my opponent, can you oppose him? So my opponent said, she was like, and then Augustine said, I tell you what, I adjourn this for 1 week. You go back, Azhar, you bring me the case, the authority, Horsbury ke apa, and then you will win this case if you show me this. He said that, you know. So he adjourned the case for a week. At that time, it was like 11:30 a.m. So after he adjourned, I walk out. Then I had lunch with the lady. At about 1:30, I was driving back. So I was like very near to the toll, Ayakro toll, when the lady lawyer called me on the handphone. Encik Azhar, where are you now? I said, I'm at the toll. Oh, she said, no, the judge called us back. Can you patah balik? Luckily, I was not yet through the toll. So I patah balik. I made a U-turn. So when I arrived in the court, I think it was 2 o'clock, macam tu. So we walked into his chambers, and there he was standing up and holding horsebreak. And then he turned around and said, come in. Luckily, you are still around. Azhar, I said, yeah, I was lucky. And he said, you know what, you are right lah. He said, I checked. It's strike law. My bad, he said. I'm so sorry. That was Augustine Paul, ladies and gentlemen, and that was my first impression of him. I was so impressed with him. And I remember when he was assigned to do that case, that sodomy one case.
Yes, sorry, one case.
I was telling everyone that was what was I saying? That was a good and proper case, proper judge for this case, because of what happened between me and him in Malacca few months back. In fact, I think that was the very first few cases that he did in KL when he was transferred to KL, the Anwar Ibrahim case. You know, and that is my experience with Augustine Paul. But of course, in the Raja Petra case, he almost killed me. He was so hard on me and on Raja Petra that we asked him to recuse himself. Yeah.
Okay, thank you, Tan Sri.
I do a small rejoinder about.
Okay, rejoinder, please, Tan Sri. I'll continue. Please join.
Now, before the next question, I thought this is important. In view of what Tommy Thomas said, remember Tommy Thomas said it is a kangaroo court. Actually, it's not sodomy 1. It is actually prelude to sodomy 1. It was about abuse of power under the old law. Yeah, the current law, of course, is 23. All right. Now, in our case, in the SRC, it began with Justice Sufyan presiding over our case. Justice Sufyan was the judge. And in fact, he began the case by hearing our application for a gag order for the same reason which Tan Sri Azhar mentioned. Could we get a fair trial? Because everybody is condemning my client. Of course, some who praise my client never get published in the media. The media always publish whatever that is controversial, whatever other people want to hear. So that was what was happening. So I applied for a gag order on the basis that, can you imagine the likes of Dr. Mahathir calling him pencuri, perompak, penyangak before the trial even begins. And the Attorney General was not taking any contempt action. So the judge saw the point and gave a gag order. Why I want to mention that is two things. One is about Tan Sri Azhar's matter. Secondly is the trial has started with Justice Sufyan. Now, I don't want to accuse the judiciary of being corrupt or intellectually corrupt, but I want to say this. My client thought that when Sufyan was suddenly transferred, just as K.C. Bora vis-a-vis Augustine Paul, Tommy Thomas say is a kangaroo court. For sure, his fate is sealed. So the same Tommy Thomas never made any comment when Sufyan was transferred out in the same building but to a civil court, and Nazlan from the civil court came to the criminal division. Now, I don't want to cast any aspersion, but my client's point of view is very important.
what is the impression you delivered to my client? Was he going to get justice because there was suddenly a change of a judge from one division to the other, and the other division came to this court? I wrote a letter to the CJM, who was then Tan Sri Zahra Ibrahim, my own classmate in the law school, to tell her this is simply not in order, because the impression given, the perception of lack of justice is certainly delivered, and my client is certainly uncomfortable. And I said, there is also this other matter. Nobody make the application. The Attorney General never make application. Nobody make application. Why is this sudden transfer? What she replied to me baffled me until today. She said this is a routine transfer. How can it be routine when there are only 2 judges affected? All right? That is what I'm saying. Do you get the feeling that there is going to be injustice? As Titi Thomas said, the trial is already doomed against Najib. That is for you to make the decision. Second, I want to tell you this, because there was a very upright, very brave judge in the federal court during the review session, which was Raman Sevli. You remember the new batch of lawyers who took over from my batch of lawyers wanted to do the appeal at the federal court. They were not prepared because they just took over about 3 weeks earlier, and they wanted an adjournment of merely 3 to 4 months. Ordinarily, anybody, Tom, Dick and Harry, walk in and say, you know, I've just taken over the case, you will get an adjournment from the federal court, because after all, this is a very serious matter and is a last resort for you to do your appeal. The adjournment was not given. They went on even without the submission by the appellant counsel. None of the appellant counsel submitted. This was Hisham Tepotek, who was the counsel. None of them submitted. All right, that's number one. That is already a travesty of justice, at least the perception of it. My client felt that he was cooked already from day one. This is what my client felt. I'm not accusing the court, but my client has that perception. Now, not only that, my client's new lawyer never submitted, but the court asked the respondent lawyer to rebut. To rebut what? Datuk Sri Najib lawyers have not submitted. Neither did they put in any written submission. No written submission. But the court said, voluntarily the court said, we will use your written submission in the Court of Appeal. Have you? Yeah, the media never mentioned this. The media mentioned that the court used the written submission. Very conveniently, the media omitted to mention that this was the written submission in the Court of Appeal. I didn't know that. Yeah, you see that? Not many people know, because you see, the media is the fourth estate. You are the fourth estate, namely, you are the protector of human rights and fair justice and whatever. But if you fail to do your job to report fairly, justice will fail, trust me. And one day, it will befall on your children or grandchildren or great-great-grandchildren, because you have left a system of no check and balance. All right, but let me tell you another thing. I've just discovered the best check and balance in this country is the new culture that we have developed, you know, a la Malaysian, namely the culture of leaking. Today you say no addendum, trust me, within a year or two addendum will come out because somebody will leak it, and there'll be a few VIPs going to be charged for not making a truthful statement
about the Agong punya titah. Trust me.
Thank you, Tan Sri. Okay, gentlemen, one last question to Tuan Adli before I open to the floor. Tuan, when Zahid met Anwar to form Kerajaan Perpaduan, did Zahid struck a deal with Anwar regarding Najib? Either you or Tan Sri Azhar can answer this question. But I think you can, UMNO man can answer this question lah.
Well, everybody already watched what the Secretary General mentioned in the social media. Have you all watched it?
Give us a gist.
You can watch the statement by Dr. Wajidi, Ashraf Wajidi. Sorry, dah dekat England dia panggil Encik Manas, so I struck Wajidi lah. Alright. Now dia kata apa? What he mentioned? He mentioned that during the night, lepas midnight, semua orang kumpul dekat tingkat atas tu. Tingkat atas you watch lah nanti tingkat berapa saya tak nak pergi on detail. Dia kata sekarang ni yang tunggu ialah Presiden ni belum lagi selesai kira. Sebab apa? Dia nak recount. Tan Sri Ad tahulah dia recount sebab dia bekas pengurusi SPR. Dia akan ambil masa sampai pagi Tan Sri Ad So what happened? Saya rasa lah ini sebagai ahli parti, mesti orang politik dia strike deal. Saya bukan ahli politik hebat lah, tapi orang tua-tua beritahu saya, dia kata dia must strike deal. Kalau misal Zahid, Datuk Zahid Hamidi, dia kalah untuk recount tu, boleh ke form government? Tak boleh form government. Itu yang jadi. So adalah arahan daripada atas, ada kata tak payahlah recount Samsul kan. Jadi boleh kita form government. Ada strike deal tak masa tu Datuk? Saya rasa ada strike deal. Bagi orang biasa lah, saya berhak cakap tak ada content pun ni politik kan. So strike deal, maka tutubuhlah kerajaannya ada sekarang. Okay, sama ada di bawah sana suka tak suka, UMNO kena check lah kat bawah kan, sama ada dah suka tak suka. 2 tahun lagi nak pilihan raya. Saya sebagai ahli parti, saya hanya follow whatever yang kepimpinan atas cakap. Tapi saya punya heart is this, I want bosku dapat keadilan yang sepatutnya. Dan soalan telah pun disyorkan oleh pihak panelis. Kalau kita sebagai human being, kita tahu apa saya cakap tadi, no the judge.
Okay, terima kasih Tuan Adli. And finally for me as moderator, some time ago I made a proposal to UMNO Selangor that a global pardon be considered for Najib, meaning that Najib be pardoned from the day he took office as Prime Minister in the year 2009 and to his last date in 2018. Whatever that he did within that 9 years as Prime Minister, he be pardoned. Exactly what President Ford gave to President Nixon, because President Nixon was involved in Watergate and a lot of other criminal activities, asking CIA to do a lot of things beyond the law lah kan. So and President Ford did that. He pardoned Nixon. I think Najib should be given that kind of a pardon, and it's a matter of political will, So we are hoping that Zahid will do something about it, Baik, I will now open the session to the floor. Any media can pose questions to any one of the panelists. Just stand up and mention your name and which media are you from. Please, anyone can start. And you can ask any question, not necessarily on our topic today. Today. Yes,
First question. My name is Hasna from New Malaysia Herald. As a Malaysian citizen, I'm worried.
You're putting to who?
Any one of you? Okay, I'm worried hearing all those sound bites from all 4 of you. You hear kangaroo court, you hear the rule of law, you hear hearsay, some accept hearsay, some don't accept hearsay, and then you hear a lot of things that is so not right. As a Malaysian citizen, I'm worried. how does it work for the people if hearsay can be accepted in court? It means anyone can say, Hasna says this, and and I got to go to trial for it, which is based on what somebody says. So, what's the future like for the citizens of Malaysia?
Thank you, Datin. I would like to answer to that. I am very concerned about the presence of deep state. I think there are elements of deep state determining the future of our country. Unfortunately, the dark side of the deep state, Tan Sri. So I am concerned too, Datin. I'm concerned too. And then I guess, Tan Sri, you would like to add further to my point?
Can I say something? Yes. Datin Hasna, can I answer you? You see, the rule of hearsay is not just a rule developed from nothing. The rule of hearsay was developed by the British over hundreds and perhaps thousands of years. The reason being, hearsay testimony is unreliable. Why? One is because the person who witnessed an incident through the five senses, your eyesight, your smell, your hearing, and so on. Five senses that the human have got, except women have got sixth sense. Now, the sixth sense is not recognized in Evidence Act. Five senses only. So if you cannot come to court and testify that from your five senses you observe this incident, if you cannot come to court, you cannot be cross-examined by the other side, who has the right to verify whether your story is correct or not. And the other thing is, you're quoting the word of somebody who's not in court, and that person's word is not a word under oath. That's why you are asked to come to court, testify in court personally, you're under oath, and you say, I observed this from my five senses. And therefore, it has got a higher chance of being accurate, and cross-examination of witnesses is called the genius of the British invention in court, because with cross-examination, the person who lies can be discovered. Quite very often, if he lies, he can be discovered. That's the reason why hearsay is not allowed. But if the law wants to allow hearsay, we have gone into what my learned friends say is a deep state, is a serious problem with fundamentals of justice in this country. So you should be concerned, because today it could be Datuk Sri Najib. Tomorrow it could be somebody who is related to you. I'm not saying just because it's related to you, you should be up and about. You should be concerned about this, because this is your country. This is justice pertaining to your people and you.
Yeah, Tan Sri, anything to add further?
I do not know about deep state. I I was in SPR and I was in the parliament. Let me just say that I didn't see it lah. I didn't see it. Although during the Pakatan Harapan version 1, I think there was a minister who said there was deep state, right, within the civil servant who were against the government and that kind of thing. So I never delved into it. I would rather work and find ways to solve problems rather than delve into problems which I imagine exist. Okay, but coming back to the addendum, apart from hearsay, I also would like to explain this creature of law evidence called adverse inference. Adverse inference. This is a creature of the Evidence Act. Yeah, I'm not making it up. Adverse inference is where the court, in certain situation, is empowered to draw an inference against A party, and that inference is adverse to that party. You get me? Yeah. So if I go to court and say Tan Sri Shafi has taken my money, 1 million ringgit, he owes me 1 million, all right, and this is what he signed, and I owe you, okay, and in that situation, Tan Sri Shafi would naturally have to respond to what I say, but he does not respond. Okay, in that situation, the court can draw an inference which is adverse to him, meaning the court can draw an inference that he is in fact owing me 1 million. Okay, that is in the Evidence Act, I think section 114. 114H. I can't remember 114, but Tan Sri Shafi will remember 114H. That, yeah. So that's different between a good lawyer and a great lawyer. So, so joke aside, but adverse inference. Now, you apply this concept to what is happening with regard to addendum. Yeah, there were 2 affidavits filed by none other than the Timbalan Perdana Menteri and none other than a Menteri Besar who are part of the government unity coalition, saying that they were shown a copy of the addendum from the smartphone of another minister which is also part of the government, and yet the government is not answering. In natural course of business in the parliament, in the court can draw an adverse inference against the government, and that adverse inference will be, yes, the addendum exists. Yeah, I'm not making it up. Go and ask Tan Sri Arif Yusof. He is my evidence lecturer. My predecessor is my evidence lecturer, and he's one of the best evidence law lecturer. Yeah, around. I think Tan Sri Shafi is what I say, correct? Adverse inference.
In fact, I raised it that 114 G and H was raised by me in the addendum application because we said I have said the addendum exists and I've asked you to confirm this. None of the 4 government departments answered. 114H say, if a question is posed to you and you have no obligation to answer, mind you have no obligation to answer, even in that circumstances, adverse inference is raised against you. But can you imagine, in this situation, you are obliged to answer. That's the situation you have.
Thank you, Tan Sri. Thank you. Tuan Adli nak tambah apa-apa?
With regard to the addendum, I think as a normal practitioner, I mean, it's about affidavits, you know. Affidavit you kena reply lah, ya. Bukan reply kata kita nak tahu wujud tak addendum tu saja. So kalau wujud, beritahulah wujud. Kalau tak wujud, janganlah berselindung di sebalik mi goreng kan. Macam tu lah saya punya pendapat sendiri saya. Dan peringkat addendum ni di peringkat leave. Jadi kita tak perlu nak pening-pening kepala. Luluskan dulu, kita tengok lah. As a judge you need to know everything kan. Kalau ikut saya lah, kalau I as a judge, I need to know, not by way of affidavit saja, by way of other documents. Sudah reply by the AG kan. So we hope the new AG can do something on it lah.
Yeah, thank you. Are there any other questions? Please.
Assalamualaikum warahmatullahi wabarakatuh. Azrul Abu Hassan from Shah Alam. I've got 2 questions actually, one for Tan Sri Shafi and one for Tan Sri Azhar Harun. First question is, we all know, I believe that there was a deal between Datuk Sri Anwar and Dr. Mahathir, when they won the election back in 2018, that sort of like a deal has been struck to let him go, okay, through pengampunan. I just want to ask whether the same also has been struck between the government of Barisan Nasional, between the party of Barisan Nasional and Pakatan Harapan before we created this new government. If Tan Sri Shafi has the knowledge regarding this one, maybe to Datuk Sri Najib. Okay, that's one. Number two, for Tan Sri Azhar is regarding a memo. I think we all know, we have seen the memo itself regarding IPIC and also Yayasan Akal Budi. So what we found is that after a few weeks, the memo has been ditularkan viral, and Datuk Sri Ahmad Zaid Hamidi got the NAA. But for the case of IPIC and Datuk Sri Najib, I heard that your brother lah, Tan Sri Idrus, wanted to also give the NAA, but somehow he changed his mind. You can answer or not, it's up to you, but basically we all want to know whether this is the truth or not, because I'm here for the truth. Thank you so much.
You answer first.
Now, you gave a prelude before you asked the question whether there was a deal struck between Barisan Nasional and the current government as a unity government with regards to Datuk Sri Najib. Is that your question? Okay. But your prelude is interesting, I must comment. Was there a deal between Datuk Sri Anwar Ibrahim and Dr. Mahathir after the 2018 election disaster of Barisan Nasional? All right? Now, I just want to answer short that one, then I'll answer this one. This is from the perspective of my client. I think my client said, and I openly said it in my submission in the review in the federal court, that my client feels that he has got to be sent into jail by the federal court. That's why no adjournment, because the election was round the corner and Barisan Nasional won 4 in a series of by-election because of the popularity of Datuk Sri Najib. I said it. I said this is not my view. This is my client's view. He's entitled to it. He feels that he has been granted injustice. You have to put him into jail so that he is no longer viable to contest in an election. And more importantly is to lead Barisan Nasional in the next election, especially the general election. Okay, that's a prelude question. But you asked me whether there was a deal. It's very hazy. We do not know if there was a deal, and if there was a deal, what kind of deal, because nothing seems to happen in favor of Datuk Sri Najib. But one thing I know, that Datuk Sri Zahid, when he signed that affidavit, it takes a lot of courage. I'm sure he has annoyed some people when he signed that affidavit, because that affidavit is a statement of truth. He saw from the handphone of the other minister, but to put it on record, and therefore the starting point of our addendum application was a very brave thing, and I think he was very sincere. But one other thing I want to squeeze in and tell you, apart from what Datuk Sri Najib felt about him needing to go into the prison in order for Barisan Nasional not to do well, was, I don't know whether you know this, Tommy Thomas recreated an investigation with regards to Altantuya, and he sent his top gun DPP to Sydney to interview what's the name of that, Cyril. Cyril was in the detention. This particular DPP went and took 5 statements, went back and told him Cyril is not reliable at all. He gave 5 statements, 4 statements, Najib not even involved, but 1 statement he was shifty. So he says we can't use his statement. Apparently, Tommy Thomas said, then use the last one lah. This is a fact. Okay, and that's why I'm brave enough to say it. Now, my client feels that what happened was, when his case was going on non-stop, SRC, no termination of the case, and he was not going into the prison, this transpired. This thing happened in the middle of between Court of Appeal and the Federal Court. My client feels, not me, my client feels that if they have got a reason for somehow to charge him for the murder of Altan Tuya, that's another best way to send him into prison because there is no bail. Therefore, he's out of circulation for the election. That's how bad our system is.
Yeah, thank you, Tan Sri. Thank you. Tan Sri Azhar, which your turn, please?
Yeah, on first of all, the first question on whether there was a deal between Tun dengan Datuk Sri Anwar for 2018 too. Of course, I do not know as a fact lah, but we lawyers, we always put 2 and 2, and then we know the answer lah kan. So the first 2 is where Tun Mahathir won the election, then he became Prime Minister. The second 2 is then there was a pardon for Datuk Sri Anwar. So equal 4 lah. That's the influence kan. So it's quite clear lah. It answers itself. Now about the question about my brother Idrus about the IPIC memo and apa tu the Datuk Sri Zahid punya memo tu, I will take PM Act punya answer lah. Saya tak campur tangan. So I have to explain. Let me explain. I always say this to everybody. I even said this to Datuk Sri Najib himself. Okay? My brother ni dalam family ni kita takut dengan dia. Dia my elder brother. Dia number 4, saya number 5. But even my eldest brother pun segan dengan dia. So he doesn't talk much, Idrus ni. He's a scholar from small. It was him and his book, his work, him, his book, his homework and his school. That was my brother. Dari kecil. From as far as I could remember him. And we were not brought up together because dari kecil I was taken away by my grandparents and he was 100% by my parents. So because of that, and then my family ni we are not close to each other because from small we are broken up. Dia ni pergi hostel sana, dia tu pergi hostel situ. So because of that, sampai sekarang we still feel a bit awkward when we are around each other. We seldom speak. We're very formal with each other. But not many people believe me when I say we never talk about work. We don't. We really don't. In fact, we don't really talk. Full stop. We seldom meet. So about kerja ni, memang I never asked him about his work. He also never asked me about my work, and that's the truth. And I hope you all believe me, but that's the truth. But to be fair, when I told this to Datuk Sri Najib, he believes it. He believed me, you know. One thing about Datuk Sri Najib lah, he take things on the face of it, and he never question you more. That's one thing about him lah.
Okay, thank you, Tan Sri. Are there any other questions while the floor is still open? Yes, please. Yes.
Hi, my name is Jonathan. 3 questions, but very quick ones. First is, Tan Sri Shafi, has you seen, I mean, we're talking about hearsay and all that, and Tan Sri said that it's no longer hearsay when someone has seen something. In the same context, why wasn't Zahid called in as a witness for the defense? Because he has claimed that he has seen a check written for from the Arabs for Najib. Okay, that's one. Because that's no more hearsay. He has seen it, right? Second question is that I'm not very sure about this, but is there a way where the defense could inquire about the royal addendum directly with the palace? Okay, and final one. Dolo's name has appeared umpteen of times. What is actually stopping the Malaysian government from bringing him here?
Yes.
Right,
Thank
that's
you.
all.
Thank you very much. Okay, Tan Sri, it's entirely your questions.
No.
I mean, so it's open. It's open. Yeah. I mean,
Open, eh? Okay.
I mean, for defense, of course, defense has the answer.
Tan Sri Azhar can answer.
Because he has seen the check. Yeah. You're saying about Datuk Sri Zahid having seen the letters of donation.
The check or the document that said the payment to the donation. He said he's seen himself.
No. What check you're talking about? Because there are no checks.
The donation.
Yeah, donation letters. There are 4 donation letters. Okay. Okay. Let me rephrase the question. The question is, there are 4 letters that are written by 2 princes from Saudi who represented the palace of the Saudi government in Riyadh. These 4 letters, the original came to the bank, which is M Islamic. The bank officers testified. They saw the 4 letters, which total up contribution of 2.6 billion ringgit. Total up, it is about that many. Ironically, when Datuk Sri Najib returned the money after using only 300 million ringgit, the money he returned again became 2.6 because of the favorable rate of exchange after many years. So, the question that you ask is interesting. The bank saw the 4 documents. Datuk Sri Najib received also the 4 documents, and Bank Negara was also given the 4 documents by not just Datuk Sri Najib, but by the M Islamic Bank CEO, I think Mr. Teck Kwang, went and gave it to Tan Sri Zeti because they were classmates in the economic faculty of University Malaya. So they were close friends. So he gave the letters and he said, Datuk Sri Najib has opened private accounts. We need your permission. And this is the letters because these accounts are open purely to receive the donation. It is put to her in the clearest term. Of course, the 4 letters didn't come in one go. It came, according to the timing that it was sent. But he went to see Zeti a few times. But the net effect is Zeti knows the 4 letters, the bank knows, and Datuk Sri Najib knows. So, MACC during their investigation sent their top gun to the Riyadh Palace to see these 2 princesses, to interview them. But because of protocol, the 2 gentlemen, the Arab gentlemen, were there with their passport, identified themselves, yes, we are the one, and those 4 letters were signed by us, but we will not give you a statement because of royal protocol. We cannot be your witness. We cannot be the subject matter of investigation because the immunity applies to them as well. But he said, we have provided our lawyer, another Arab man,
a lawyer, full-fledged lawyer, to be here. He will give a statement on our behalf, so that you are satisfied that these 4 letters emanate from us. So MACC officers recorded the statement, and guess who went as MACC officers? The current commissioner, Tan Sri Azam, was there. The former MACC chief, Tan Sri Zulkifli, was there. Jolo lawyers were there for some reason, I don't know why. And 2 Malaysian lawyers were there, including, if I'm not mistaken, Francis Ng was also there. So this statement was taken. So came back, evidence was led of the proceeding in Riyadh. So to answer your question, firstly, it is not hearsay, because MACC officers testified, they confirm these are 4 letters from the palace of Riyadh in Saudi. Okay, so that's number 1. Number 2, even if you were to say, the people who signed is not here, technically it is hearsay. We are saying it is not hearsay because we are saying the 4 letters affected the mind of Datuk Sri Najib, because he was influenced by the letter into thinking that these are donation money that came into his account. This is sometimes regarded as not part of hearsay, or some school of thought say it is an exception to hearsay. I give you an example. In 1950, there was this poor Indian man called Subramaniam. Okay, Subramaniam was pushing his bicycle with a basket during emergency time, where communists were everywhere. He had some offensive item given by the communist agent to him to be delivered somewhere in the new village. Bullet or something, yes. And the communist fella told him, if you don't do it, we will kill you, because we know where you are. You come in to do rubber tapping, we'll kill you. So when he was stopped by the police, he said, I carried this because this joker, the communist, told me I'll be killed if I don't do it. So his defense was defense of coercion. Coercion means he was forced to carry it. So the Privy Council decided that it is an exception to hearsay, because the truth of what the communist fella told him is not relevant. It's the fact that what they told him affected his mind into believing he will die if he doesn't do it. Same thing with Datuk Sri Najib. His mind was affected by the 4 letters. Namely, that he genuinely thought the letters were the starting point of donation money, and what went into his account were donation money exactly to the 2.6 billion that he expected, which is equivalent to 1 billion US, which was promised by King Abdullah at the meeting in Riyadh. Is that clear enough?
Yeah. Second question, are you going to see the palace? Is the defense team going to see the palace?
Yes. All right. Your question is actually very, very much, I mean, it's a brilliant question, but based on pure common sense, isn't it? If the young Di-Pertuan Agong, previous one, number 16, has signed the addendum, and people are, to use a Penang nomenclature, people in parliament, people in the cabinet are playing achilot. You know what is achilot? Achilot is hide and seek. Yeah, I'm hiding the addendum, and then you say, where is the addendum? It's hearsay. So if they're doing that, one would expect the former young Di-Pertuan Agong to say, what are you talking about? I gave a titah. If you don't follow my titah, it's a total murka. Murka is very serious offense, offending the young Di-Pertuan Agong. But we have, this all depend on the personality of each and the individual young Di-Pertuan Agong. Young Di-Pertuan Agong number 16, the Sultan of Pahang, whom I have got the greatest of respect. does not want to enter into the controversy. And he kept quiet. And the matter becomes more and more acrimonious day by day.
Last question regarding Jolo. Where is Jolo?
Okay. You asked about Jolo?
Yeah,
Okay.
what is actually stopping him?
Okay. There's nothing stopping him being taken. Initially they say he was in China. Then they say he was in Dubai. Then they say he is somewhere else. But, they say Macau. But from the testimony which I grilled Jasmine Lu, I think he is in Myanmar protected by the generals. Because he was able to get the passport to Jasmine Lu. He was able to get Jasmine Lu entering Myanmar without her Malaysian passport being chopped, and to exit without the chopping. And Jasmine Lu was traveling on a Myanmar passport, and she confirmed it was Jolo who arranged for these passports. And you know, in Myanmar is a cowboy country. Yeah, worse than a banana republic currently. You can do wonderful things there.
Yeah. Thank you, Tan Sri. Tan Sri Azhar, any last word?
No, I think actually I've said my piece. Unless there are questions, I could help. I could assist the journalists more.
Okay.
It's just that my presence here. I just want to state the law, as I said. I think it is only fair that Datuk Sri Najib be told of the result of his royal petition. It is only fair, and he has a legitimate expectation to be told.
Okay.
And once he is told, then he could ask for legal advice for his next course. And now we have a situation where he wasn't told, and Tan Sri Shafi has to file mandamus, and even the mandamus were dismissed now is being appealed. So question is it that difficult to know the result of petition in Malaysia? That's a question. I mean, if we deconstruct the whole thing, it boils down to that. What is the decision on my petition? That's all. And I want to know. I have the right to know. That's it.
Yeah. Thank you, Tan Sri. Tuan Adli, any last words?
Yeah. It's a pleasure to come here today. But first and foremost, that concerns about what's happened to Bosco case, the defense will come in the 2nd of December, which is coming soon. We've been informed by your PC Tan Sri that there will be about 11 witnesses will come in to testify by way of the PC that we heard from the press. We hope the press will give very fair and thorough reports regarding to this case, and there might be other questions that not been asked by the media, but maybe I'll convey to you later on this.
Thank you.
Because we want the truth, and we hope that we'll get justice, and that Bosco will be acquitted.
Thank you.
Thank you very much.
Thank you. Tan Sri, you want to continue with Tan Sri Azhar point?
There's a short rider. Tan Sri Azhar raised a very interesting point. What is the problem of telling Datuk Sri Najib especially, that there is this addendum? Okay? Now, you be wondering, why don't they do that? The answer to that is this. You remember Datuk Sri Anwar Ibrahim's own pardon was challenged, I think twice. That pardon, the pardon board did not constitute, did not assemble. That's a fact. The Attorney General wasn't there because he was forced to go on garden leave. And before going on garden leave, he did not appoint somebody else to take his place to attend the pardons board. So there was no representation from the Attorney General. The Attorney General's report wasn't there. The Chief Justice report wasn't there, which is required. All right? And I'm told there was actually no meeting of the pardons board, except that the King issued his decree of a blanket pardon. The court held, it doesn't matter, once the royal pardon, the decree is granted, you can't challenge. Which is the law? Which is the law? What is the situation here? The addendum, if admitted, if the government say, there is the addendum, you can't challenge it. You can't say it is not done in the pardons board, outside the pardons board, or in the toilet. Doesn't matter. If there is a decree from the Yang di-Pertuan Agong, the government will lose the day because they have to grant the addendum privilege to Datuk Seri Najib. That is the reason why mati-mati pun dia kata tak ada, tak tengok. But they cannot say tak ada, sebab that will be lying. So they main acilot lah.
Thank you, Tan Sri. Last question, we are going to close the session. It's almost 7 p.m. now.
Okay.
We have exceeded 6 p.m.
Sorry. My question is, I'm not sure how the law works. Okay. But we've been hearing from the trials and even today, it's Zesti's advisory to Datuk Seri Najib that to put it in his personal account, or the Bank Negara is aware of the transactions and all that. Can Datuk Seri Najib's team, legal team, take action against Tan Sri Zeti for that?
Tan Sri Shafi, is your question. Yeah.
There are many things I believe Tan Sri Zeti did not tell the truth. She would otherwise have been an honorable witness, but because of the implication of the husband and the 2 children, she was forced to be a witness that is other than truthful. Okay? So your question is, in her untruthful answers, can we take action? Can Datuk Seri Najib take action? First and foremost, I will have to decipher for her untruthfulness, what is the damage that she has caused Datuk Seri Najib? Because I tell you, Tan Sri Azhar will tell you, we will need to know, is there damage? Is there harm? Harm, yes, because her testimony in some way has led to the calling of the defense, maybe even conviction, because at the rate it is going. But the difficulty is the apportionment of what she said that result in whatever tragedy that my client may face. That will be the problem of thinking of a civil suit. Yeah?
Thank you, gentlemen. Thank you very much for your support, for your patience. We have been here for the last 2.5 hours. It's really a long town hall session. And thank you very much to our panel, Tan Sri Shafi, Tan Sri Azhar, Tuan Azli, for sharing so much legal information with us. It has been a very informative sessions, and we look forward to more town hall sessions of this nature. Thank you and good evening.
Thank you very much to our moderators as well as speakers.